Welcome, everyone, to the Federal Bar Association Ketam Sections, The Rounds, FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, Programming Chair of the Ketam Section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hello, Scott. Happy summer.
Happy summer to you. And we have a few things to talk about. Tejinder, let's start with something a bit different, a case from the Federal District Court rather than our usual fare from the Courts of Appeals. In U.S. ex rel. Bassan versus Omnicare, we have an intervened Ketam case that went to a jury trial before a judge in the Southern District of New York. The jury found that the defendants, two pharmacy companies, Omnicare and CVS Health Corporation, were both responsible for submitting millions of fraudulent prescriptions. The jury also found that Omnicare had caused about $136 million in actual damages to the government, trebled under the FCA to just under $400 million. So the court needed to decide the statutory penalties to be levied on Omnicare. If the court were to follow the letter of the law, those penalties would have added up to at least $26.9 billion. But the government sought a far smaller amount, and on July 7th, the court followed the government's proposal, calling the resulting punishment serious but not surreal. So, Tejinder, tell us a little bit about this case, how it relates to other excessive fines cases we discussed on the rounds, including Grant v. Zorn in the Eighth Circuit, a case that the Supreme Court just denied cert. What do you think?
Yeah, so this is a very interesting case. The setup is that Omnicare and its parent company have presented millions of false claims. The government voluntarily reduces the penalties it's seeking to a 4-to-1 ratio between the penalties and the single damages. And those penalties are divided up. CVS is jointly liable. Omnicare is liable for all of them, and CVS is jointly liable for 30% of them with Omnicare. And so the defendants both say this is excessive, and they point to due process precedents from the Supreme Court, specifically this case called State Farm versus Campbell, which was decided in 2003, where the court said when you have punitive damages awards, you're going to want to have a single-digit multiplier between the punitive amount and the compensatory amount. And, if the damages are really large, that ratio should go down. And so if the damages are really big, maybe it should just be 1-to-1. And what the court does is it says, well, do these due process principles apply here in excessive fines land? And it says, kind of. The decision is not controlling. I'm not going to follow it as if it guides us. The excessive fines test under the Eighth Amendment is whether this is grossly disproportional. But I am going to borrow this idea that the bigger the damages, the lower the ratio should be. And so the court says here you have pretty big damages vis-a-vis Omnicare, and I think a 4-to-1 ratio is okay. Then when the court gets to CVS actually had no damages attributed to it. So the ratio is effectively like infinity. And the court says that's fine too, for CVS to nevertheless be liable for 30% of the penalties, because when you have lower damages, you can have a higher amount of penalty levied. And so it shows how this inquiry is kind of flexible. There are these sliding scale principles. There's a lot of, I think, guesstimation and making it up when it comes to figuring out what's grossly disproportionate. But that's not because the courts are doing anything wrong. It's because the test is just fundamentally a little bit subjective. What's the difference between disproportionate and grossly disproportionate and too disproportionate? I mean, there's just a lot of room there for the imagination, and you see it playing out.
On the appellate level, we've seen two fairly straightforward 9B pleading cases that came up over the last period. We'll start with U.S. ex rel. McKoy versus Atlanta Primary Care, Peachtree PC in the 11th Circuit. Tejinder, what happened here?
This is the case where an employee of the company who didn't have a ton of firsthand knowledge, but had sort of seen stuff around her desk, brought multiple kinds of claims against the defendant for various sorts of fraudulent conduct. And all of them were dismissed on Rule 9b grounds. If you recall, the 11th Circuit has a relatively strict Rule 9b standard requiring either representative example false claims or a lot of firsthand information about billing that makes it clear that claims were definitely presented to get over the pleading hurdle. On appeal, the 11th Circuit splits the baby a little bit, says, well, one of your types of claims for which you had a representative false claim is good, nothing else is good. So this is just an ongoing application in an unpublished decision of the 11th Circuit's pretty strict Rule 9b standard, which is stricter, I think, than many other circuits.
We have U.S. ex rel. Flanagan versus Fresenius Medical Care Holdings in the First Circuit. This is an kickback statute case that applies the holding of Regeneron that we discussed earlier this year. Tell us about this one.
Yeah, so as we discussed under Regeneron, there are two ways that anti-kickback statute violations can lead to FCA liability. The first is under the 2010 amendments to the AKS. If the claims result from the kickbacks, then you can have liability. That requires a showing of but-for causation. The second method is false certification. You said you complied with all the laws, including the anti-kickback statute. You didn't comply with the anti-kickback statute. If that is a material non-compliance, you can be liable even absent but-for causation. The standard is materiality, not causation. Here, the court looks at this through the lens of Rule 9b. So the plaintiff says there are all these kickbacks going on that took the form of sweetheart lease deals, above market compensation, and so on. And as the case moved forward through the appellate process, it got narrower and narrower. Eventually, the plaintiff was just talking about like one physician as the example of who was getting kickbacks. So on the resulting from theory, the but-for causation theory, the First Circuit says, yeah, you've shown that the defendant cared about renewing the contract with this physician because he was a big referrer of patients, but you haven't shown that the purported compensation they gave him actually caused a single claim to be presented. So you failed but-for causation under Rule 9b. I think it's a pretty clear example of a court not willing to draw inferences in the plaintiff's favor because of the Rule 9b standard. Then on the other standard, the false certification standard, the court says you don't have nearly enough information about what was in the forms and reports that the defendant submitted to the government. And so you haven't, with sufficient particularity, identified what certifications they're making or what they were saying about the relevant transactions. So again, Rule 9b problem, case goes away.
We move to the Ninth Circuit. We have U.S. ex rel. Island Industries, Inc. versus Sigma Corporation, an FCA case about the avoidance of customs duties. Of course, this is a topic with increasing relevance to our bar. Tejinder, in this non-intervened case, a jury finds for the relator. On appeal, one of the questions was whether the relator's initial complaint should ever have been filed in the district court. This was in part because the Ninth Circuit had set a previous FCA standard that in a case that these types of cases should be filed with the Court of International Trade. So how did the panel untangle these jurisdictional issues?
Yeah, this is kind of a funny one. The court had held in 2004, the Ninth Circuit held in a case called Universal Fruits and Vegetables, that an FCA action to recover customs duties had to be brought in the Court of International Trade and could not be brought in a U.S. district court when the case was commenced by the United States. The question here was, well, is that correct? Now, the court says it's not. The court says this case is commenced by a private party, not by the United States, so it doesn't fall under the language of that holding. It's kind of a weird distinction to draw, right? Because it would be strange for the United States to be bringing all of these cases in one forum and for private parties to be bringing them in another. And it would raise a funny question about, well, what if the government intervenes in a case brought by a private party? You know, does it change character? But what I think was animating the court's decision, it talks about this in a footnote, is after the Universal Fruits case, when they transferred the FCA case over to the Court of International Trade, the Court of International Trade said, no, we don't have jurisdiction over this, and give a very detailed analysis explaining why trying to recover FCA damages is not the same thing as trying to recover customs duties. And so you have this weird situation where actually, you know, the Ninth Circuit says you have to sue over there and the Court of International Trade says you can't sue over here. So maybe the United States can't sue anywhere. But anyway, I think what the court is trying to do without a panel overruling its own precedent, which it can't do as a matter of just appellate practice. They're trying to create an avenue for these lawsuits to be able to proceed somewhere. And so they've recognized that these types of cases brought by relators can be brought in the district courts.
There's also this question of whether the anti-dumping duties at issue were an obligation under the FCA to gender. What did the panel have to say about this?
So yeah, there's kind of a two-parter here that's interesting. The first argument that the defendant made was actually the custom statutes preempt the False Claims Act in this area altogether, and the court says no, they don't. These two remedies exist alongside each other. The second issue was this is brought under the reverse FCA provision, which applies when you try to avoid an obligation to pay money to the government. And so here the argument was these anti-dumping duties were the obligation that the defendant tried to avoid. And what the defendant says is like, look, the process for assessing anti-dumping duties is actually really, really complicated, which is true. It's a multi-stage process that culminates with something called liquidation, which is the sort of a final determination of what duties are owed. And the number can shift a bit before then. And so the defendant said, because this process is so uncertain, you don't have a sufficient obligation concrete enough to impose FCA liability upon us. And the court says no. It was quite clear that you were required to pay some duties. It's true that the amount of duty was not known, perhaps right at the beginning, but that doesn't matter for purposes of whether you had an obligation. And I think that's consistent with the statutory text, which says obligations need not be fixed in order to be actionable.
Tejinder, on July 2nd, we saw the announcement of the False Claims Act Working Group that will coordinate FCA enforcement priorities between the Department of Justice and HHS. The group named 6 specific areas it will target, and it also talked about standards for C2A dismissals, among other things. Did any of this news strike you as good for either relators or defendants?
Yeah, I think it's good for both in the sense that it's always nice to have clarity about what the government's priorities are. If you are a relator or relators counsel, it's helpful to know where the government is focusing its enforcement efforts so that you don't find yourself bringing cases they really don't care about. Similarly, if you're in the industry and one of these priority areas affects your business, it's really helpful to know that so that you can get on top of your compliance responsibilities and do what you need to do to make sure that you don't end up on the losing end of an enforcement action. Some of the areas that we saw were areas that the government has discussed before. So Medicare Advantage is discussed, and Medicare Advantage is swallowing up just a huge proportion of healthcare dollars, and the number will only grow in the future. So that one's not surprising. They talk about drug, device, and biologics pricing. Again, not too surprising. The government has talked about that before. Then they talk about one that's kind of new. They say barriers to patient access to care, including violations of network adequacy requirements. So this is another issue that affects managed care organizations. But I don't believe they've talked about this one before. And so that's new and it's interesting. The other ones, they talk about kickbacks. We've seen that before. They talk about defective medical devices that impact patient safety. It's interesting that they focus specifically on devices and not drugs and devices there. I don't know if that means anything, but it's worth looking at. And then another really interesting one is they talk about manipulation of electronic health record systems to drive inappropriate utilization of products and services. So I think software vendors now actually probably have to pay a lot of attention to the way their software is both being shipped and being configured by users in ways that might cause overutilization. You mentioned also this thing about dismissals. So there is this language in here that says HHS leadership and DOJ leadership are going to put heads together more often, I think, to talk about when to dismiss qui tam complaints. I think for most relators counsel, that probably raises an eyebrow. I think the prevailing sentiment is probably that, that means increased propensity to dismiss. But you never know. It could be that maybe the government feels too many dismissal motions were filed and it wants to review those. But I think it's probably the other thing. Anywho, we'll see how this group works going forward. They're going to meet, I believe, monthly and have chats about what's going on in FCA land. I think at least it signals a high degree of commitment from the administration to the continued enforcement and use of the statute, which is good for the country.
Tejinder, thank you. And thanks to each of you for joining us for this episode of the Federal Bar Association Ketam Sections, The Rounds, FCA News with Tejinder Singh. We'll see you next time.